And welcome back to Consumer Choice Radio, broadcasting here on the Big Talker 106.7 FM and Sauga 960 AM out of Ontario, Canada. We're speaking with Jennifer Huddleston. She's the Director of Technology and Innovation Policy at the American Action Forum. Jennifer, thanks so much for coming on the radio program.
Thanks for having me.
So I wanted to point many of our listeners to a paper that you wrote last year, and I thought was very prescient because we are talking about the various leaks, the data hacks, all these things that are coming in the news. Every day we hear about hundreds of millions of accounts or hundreds of accounts and all this issue with consumer and data privacy. And there are a lot of people who've discussed the need for a federal bill or some kind of privacy law. I know that various states have different versions, but what is your kind of take on some of these leaks and hacks and what the law should kind of be about that?
I want to start off by saying there is a difference between when we're talking about data breach and the laws that govern that element of some of these news stories we may have heard, as well as when we're talking about broader data privacy questions. So oftentimes when we're talking about data breaches or hacks, we may be talking about where state level data breach law applies, in which case all 50 states have their own data breach law, which is each one of which is a little bit different in terms of the information it covers, the amount of time you have to notify those impacted, how you were supposed to notify people, what is and isn't considered a breach. And then we also have the FTC, who is engaged in both data breach enforcement as well as data security enforcement and data privacy enforcement from a consumer protection point of view. There are also questions about data privacy in the sense of some people are asking, are there certain types of data that we should have more limits on companies collecting at all, or what they can do with that data once they have it? And that's where we see a lot of conversations around, for example, the European General Data Protection Rule, GDPR, or California's Consumer Privacy Act, CCPA, and whether or not there also needs to be any kind of federal law addressing kind of data rights or data privacy as well.
So on the question of data breaches, I know that often in the financial sector, whenever there are issues, some of the grievances that we have is that a company will have to pay a fine, but that fine goes to the regulator rather than being redistributed to the people who were impacted. Is there any framework in the United States or elsewhere maybe where consumers are properly, let's say, compensated for any of the violations that may occur?
In some ways, these are questions that occur around what is the appropriate way to enforce these laws if there is a violation that has occurred and we found that a company was guilty of that violation, whether it's a data privacy violation or a data breach violation. We've seen in some cases where companies after a breach will offer things like credit monitoring as part of a settlement, or there will be some other element that does attempt to make consumers whole. But there are a lot of questions about what it would mean for the market if there was a shift in how these laws were enforced. So right now, we largely have government enforcement in the US by the FTC, where the FTC will either bring a case against a company for consumer harm when it comes to data privacy, or they will enter into a consent decree or a settlement with the company rather than taking that case to trial. In some other cases, though, people have advocated for a private right of action, the right of class action lawsuits or of individual plaintiffs who feel that they have been harmed to bring a case against these companies. There are a lot of concerns about what that could do given the cost of litigation, and particularly in the United States, given the fact that you can bring a case that gets lost and the company still has to bear the cost of that litigation, even if it's later vindicated in court that it was completely innocent. we can think about how with large companies, the cost of compliance and the potential costs associated with litigation can get quite high. If you're talking about one of the big tech companies, we can certainly imagine that there would be potentially a lot of people trying to sue them for things that might not have actually been violations in hopes of a potential settlement. However, for smaller companies, this can be particularly concerning, given that, as I mentioned, even if a company is vindicated in court and proven that there wasn't any violations, the cost of that litigation can be something that could be potentially business ending, particularly if they were completely innocent.
We're speaking with Jennifer Huddleston of the American Action Forum. You can follow her on Twitter at JRHuddles. That's a great Twitter handle there. One question I had, Jennifer, that you mentioned in your research, and we'll link to this. This is specifically a primer on data privacy enforcement options, and you leave no stone unturned. One thing you mentioned is the European Union's General Data Protection Regulation, GDPR. I think some of us who bounce between Europe and the United States are definitely familiar with this, and VPNs are our best friend for that very reason. But what are some of the problematic aspects of that particular rule, and is that something that perhaps American regulators should emulate in any way, or should they run away from it?
Looking at GDPR, we can see some of the unintended consequences that can come from heavy-handed privacy regulation. Now, there certainly are cases where we definitely want to value privacy, but we can't pretend that data privacy does not exist without trade-offs, whether it's trade-offs to potentially innovative uses of data, whether it's potential trade-offs to speech. And what's interesting is now, a little over 2 years out from the GDPR, we're starting to be able to observe some of the real consequences of what this type of regulation could do. So we've seen in many cases a decrease in investment in startups and micro companies out of concern of would they be able to cope with the compliance costs associated with GDPR. We've also seen in some cases where companies have chosen to pull out of the European market. And the question is, what does that mean? So at the start, there were several US newspapers like the LA Times that were not available in Europe, if like you were saying, bouncing back and forth between the States and Europe, because they didn't find that the cost of complying with GDPR was worth it for them, given their size in the market. We also have seen questions about, does this actually improve privacy, or does it just kind of change where some of the concerns are? So for example, there was a researcher who, using GDPR request with his then fiance's permission, was able to get a good bit of her information from various companies with very little verification by submitting GDPR requests. Similarly, I think we've all seen those cookie pop-ups and the question of, does clicking yes or no actually change your privacy preference in any way, or does it just give us that additional friction when trying to use the service that we wanted? And I think when we're talking about privacy, that's what's really important to recognize, is that there are a wide range of privacy preferences that we have. All of us, on this show, everyone listening probably has different information that they personally find more sensitive. And so when we're talking about whether privacy regulation is appropriate, we really want to look at, are there areas where we generally agree there is a more significant risk in this data, such that maybe we're willing to make those trade-offs that may make it more difficult for innovation, or may make it more difficult for certain information to be shared.
And on that note, I mean, one issue that we've written about in terms of the sharing of that information was, I know one case in Europe from July, where there were questions of whether or not it would be legal for multinational entities to transfer data from the EU to the United States over privacy concerns. And that created or would create effectively data silos. Have you looked into what the impact of data silos are, or the kind of restrictions and segregated impact that may have on global commerce or anything along those lines?
I've looked a little bit into data localization requirements. It's not an area that I've done a lot of work on, but I think one thing to recognize is one of the big benefits of the internet is the ability to share information across borders, and that includes data. And when you're talking about multinational companies, they're often working in several different environments at once, and it may not be practical to have kind of data localization requirements that require that they store the data in the country that it was originally collected in, or in the kind, you could see this occurring at an even more local level. But I think the other element there is that we continue to have a debate about, what are the impact of these European regulations on American tech companies and on American consumers. In some cases, we've seen kind of GDPR become the default when it comes to data privacy, as opposed to the more light touch American approach that really allowed a lot of innovation to flourish and a lot of tech companies to emerge with minimal barriers and really serve consumers with products that they wanted.
And I definitely have appreciated a lot of your research into this topic. It's definitely helped us approach this and figure out how consumers can be served best by your system. And I definitely do want to praise Jennifer your research on e-scooters, as you're one of the pioneers there in good academic writing on that. What other kind of research are you working on that our listeners should know about?
It's certainly an interesting time to be working in tech policy because we have a lot of really exciting things, whether it's e-scooters or autonomous vehicles, or even just the ways we've been able to connect during the pandemic. I think many of us have started to really recognize the benefits of technology as we've been working from home for a year now, and over a year now, and have been able to stay connected with friends and family in ways that a decade ago wouldn't have been able to. At the same time, we're seeing this kind of techlash of a lot of policymakers and pundits kind of skeptical of tech companies, and particularly of some of the larger tech companies, when it comes to things like calls to break up big tech, or calls about reforming Section 230, or changing content moderation rules. So I've done a lot of writing about why the principled approach to technology, and why continuing the light touch regulatory approach as opposed to more heavy-handed intervention into the technology market helps support innovation and helps us get the kind of next generation of innovation and the next disruptor and that next great idea that we often can't predict. And so we really want to continue to create a system that allows new entry into this market and supports, disruption that we could never predict, rather than accidentally locking in existing giants through heavy-handed regulation.
And if I could ask one question on the Techlash, where do you see the greatest threat? Is it via the courts? Is it via Congress and legislators? Is it, just new competition? Where do you kind of see the progenitors of this Techlash, and what should we really be most concerned about?
I think we've seen some very interesting things recently. We are seeing a lot of congressional debate over what the appropriate use of and legal framework for antitrust is. And that's certainly concerning, because changing antitrust away from a consumer welfare model would impact not only the technology sector, but far more than just that sector. It could impact nearly every sector of the economy. We're also seeing a lot of disruption in the states in terms of attempts to regulate different elements of the internet. I mentioned earlier California's Consumer Privacy Act. We've also seen state level law legislation proposed regarding online content moderation. California also has a net neutrality law. We've seen various states propose different app store regulations. And what's really concerning there is you have the potential for a patchwork to emerge that could really disrupt innovation by not allowing the same product to be easily available across state lines and really interfere with potentially with interstate commerce and the development of new products.
We've been speaking with Jennifer Huddleston, Director of Technology and Innovation Policy at the American Action Forum. Jennifer, thanks so much for coming on.
Thanks for having me.